ahead and have a seat.
Good morning. We're on the record in case D430049, Marnie Victoria versus Victor Victoria. Cancel your appearances for the record, starting with plaintiff.
This is Francesca Resch, bar number 13011, with the plaintiff, Marnie Victoria, who's present in my office.
Okay. Ms. Robinson?
Good morning, Your Honor.
Okay, your appearance for the record, please.
Good morning, Your Honor. Amber Robinson, bar number 10731, also present in my office with Victor Victoria.
Okay. Has there been a resolution in this matter, counsel?
I think that we might have some resolutions, but not a global resolution. I just received an email from counsel, and I can say that I think we've reached a partial resolution to modifying the visitation schedule. For starters, we have agreed to move the Wednesday visitation that Victor has, the defendant has after school on Wednesday. We have agreed to move that to Friday, specifically that the visitation would begin Friday after school, and if school is not in session, it will begin at the same time that Monet would otherwise be released from school, and continue until 7:30 p.m., and any extracurricular school or social activities Monet has will take precedence. So visitation would either begin after those activities end or continue until he drops her off at those activities, depending on what time those activities would be.
Okay, Ms. Robinson, is that your understanding of the timeshare?
Yes, Your Honor.
Okay.
And then
any other issues,
also, we discussed doing an every other Sunday visitation because it appears that for whatever reason, every Sunday just isn't working. In the past 9 Sundays that we had since the last court hearing, there have been 3 visitations that took place. So my client requested to modify it to every other Sunday, and also to make the return time, to modify the return time. Per the decree, it's 7:30 p.m. Every other Sunday.
Oh.
That's making it too difficult for my client trying to make sure that homework's done and everything's ready for her to go to bed on time and get ready for her at school. So she requested to modify it to 6 p.m. and to every other Sunday. And obviously to still keep the requirement that notice be provided that he will be exercising that visitation.
Okay, is that your understanding, Ms. Robinson?
Sorry, that part isn't, and I guess my email didn't go into detail on that, so I apologize, Francesca.
Counsel, so it sounds like, look, this is my concern. If we're not doing it every Sunday, I would want it to be more than less. And the other thing is, I would want it to be if one is missed because of we're allowing extracurriculars or everything else to stand in the way of parental visitation, then I would expect time to be made up.
Like I said, the reason why my client made the request to modify it to every other Sunday is because in the last 9 Sundays since the court hearing on January 16th, 3 Sundays visitations were exercised.
Okay, but I didn't understand why the others were not, counsel. That was my concern. I don't know, was it dad couldn't do it, the child couldn't do it? What's the deal?
Well, I can give you a breakdown as to what occurred. January 19th, the first Sunday visitation after the last hearing, no notification was given to my client and no visitation occurred. Okay. January 26th, again, no notification was made to my client and no visitation occurred. Okay. February 2nd, that was Super Bowl Sunday, notification was given to my client via our family wizard that he could not exercise visitation. I don't know the reason why, because we have evidence that he was in town, but he just chose not to exercise the visitation. Okay. And the same for February 9th. He did provide notice, but we have evidence he was in town, so I don't know why he chose not to exercise the visitation. February 16th, the visitation did not occur because Monet did have a cheerleading event in California. So my client and the child went to California for the cheer event, Dad did have knowledge of this cheer event and had an opportunity to attend as well.
Okay.
February 23rd, visitation did occur. March 1st, visitation did occur. March 8th, notification was provided to my client via our family wizard. The only information we had was that he was unavailable, and so visitation did not occur. And then March 15th, visitation occurred.
Okay.
So,
all right. So it sounds like there's a lot of scheduling issues. So, Ms. Robinson, what is your client requesting? Because I'm looking at this, the no shows, and then the other changes. It seems like, I mean, if your client doesn't really want the Sundays, then their request every other one isn't a bad request. But tell me what your client's position is, counsel.
So, yeah, he's good with the every other Sunday request.
Okay.
But instead of changing the times versus a school day or a non-school day, he just says that's just too confusing. Let's just keep it at 5 p.m. On Sundays, and the Fridays you would exchange at 5, right? That's your request.
No, Friday would be 7:30. Pick her up from school at 2:10 and drop her off at 7:30. Non-school in summer, the same time, 2:10 to 7:30.
Okay.
Sunday 9 to 5.
Sorry, I misspoke.
Okay, counsel, explain to me what he believes, their agreement, what he believes he wants.
So he would do, we just moved from Wednesdays to Fridays, so that would remain at 7:30 exchange. He's fine with that. And then Sundays, he would request, he's fine with it every other Sunday, 9 to 5. He'll do the 9 to 5. And then what he would like is if he is able to exercise a Sunday, he would like that would not be his under this new modification. He would like to give Marnie 7 days advance notice and let her know that he could take that Sunday.
Okay.
So, Your Honor, the issue that we have with that is, as we just described to you, it's so inconsistent. Like, there's no notifications, no shows. There's notifications and no shows, and then there's notifications and appearances. The reason why we requested every other Sunday is so that my client could have some consistency to know and expect what Sundays, full weekends, she's going to have with the child. So she can put it on her calendar like, okay, this is Victor's week, this is my week, this is Victor's week, so she can plan ahead for that. So if he still gets the opportunity, like, okay, well, here's my 7 days notice, I'm going to exercise visitation on your Sunday, and then
She can't make plans. Your concern is she can't make plans then because she's already will have made plans by then.
Right.
I guess could we have it be maybe just a little bit looser? I understand Mom wanting to plan, but not all of us have set plans every single weekend. So
Correct.
if she's able to, and she doesn't already have prior scheduled plans.
So more like a request as opposed to a notification?
Correct.
This is the thing.
Yeah,
I want Mom
doesn't
to
have-
understand, Ms. Schrish, a couple things that Mom needs to understand. Because she has primary physical custody, this court is very strong on enforcing the fact that NRS 125C0035, in the A through L, Section C or Factor C is really important to this court. And when you have primary physical custody, Mom needs to understand that she has a duty to facilitate a relationship ongoing, that part of the statute continues. And the court expects her to do so.
And she definitely understands that.
Okay, but I'm just
she
saying,
also
if we're
can't
going to do
force
it
him.
with request, but hold on, counsel, if we're going to do it with request, then I just want, it would be by request, as you both have just stated, but I just want her to be clear on the fact that the court expects it. This is what I don't want to have happen. Mom gets mad at Dad, and he makes the request a week ahead, 7 days ahead, so he makes it Saturday the week before, it's even 8 days. And then Mom says, oh, no, I must have something then, coming up with something that she didn't already have. Because if I find that, then that's a concern for the court.
I understand that, and my client understands that as well.
Okay. I guess, counsel, Ms. Robinson, you're saying that it just be by request, not by, not a notice and automatically occurs by request. With my admonishment that everybody needs to try to accommodate visitation with Dad because it's important between the relationship between Monet and her father. So, does that work for everybody?
Yes, thank you, Your Honor.
Okay. All right. So that'll be the order as far as that goes. The other issue we had at issue was, the parties were both to enroll in UNLV co-parenting classes. That occurred?
Yes, Your Honor.
Yes,
My client
Pardon me, Ms. Rush?
my client
my client's last session is tonight.
Okay, sounds like both of them did it. That's great. The other issue before
What
the
were
court...
you going to say, Amber? I'm so sorry.
Yeah, Your Honor, my client had a request on that. He's enrolled. He's completed 4 classes. He received an email because of everything going on from UNLV canceling all the rest of his classes. He would request a waiver of the remainder of those classes.
I think we have the same problem on the other side as well.
It's hard to fit into his schedule, and now with everything going on.
Okay, the court is going to waive the last... I'm glad you went to the 4 sessions. Mom went to all but 1. Is that right, Ms. Resch? Is that what I heard?
Yes, and I have to. She has to my understanding, they haven't canceled her last session. It's tonight.
My guess is they might.
Forward.
They did get an email saying it's moving forward. Yeah, my guess is I believe they're canceling everything after this week. I think is what all of those UNLV programs are doing. So, I could be wrong. But
if there's an opportunity for him to take those remainder of classes, my client would request it because co-parenting is a big issue in this case.
I agree, Ms. Robinson. I'm not going to waive it, but if he gets a notice that says they aren't going to offer it, I can't make him go to something that's not offered. But if it's available, I want him to complete it. These parties have enough drama between them that Monet doesn't need to be involved in the middle, and I think the co-parenting classes might be helping. So, hopefully, that'll be my order, Ms. Robinson. I'm not going to waive it for him, but if he's going to have to provide proof that they've canceled it. If he can't go because of that, I'm not going to hold him in contempt or anything like that. Clearly, the court understands with our trying times right now that we have to deal with that. The other issue was the arrears for the, have we come up with an agreement on that?
So, where Franny and I disagree on that issue is the Seven Hills request. And so I've added up the numbers, Your Honor. And so how she's completed the numbers, she's done it with interest. And Victor's argument last time we were in court was I stopped receiving these notices from her. She used to mail them all the time to my house. I stopped receiving them. So if the court notices, the arrears only go back to April 2019, which shows he was always paying. So we would just ask the court not to...
I believe we're talking on 2 different pages, counsel. I was looking at the medical arrears, though. You were talking about child support arrears, counsel?
Yeah, and I have the emails that my client sent to Victor dating back to April 1st. So if this needs to become an evidentiary issue, we can provide that. We can disclose these through formal discovery. I mean, if
Ms. Robinson, Ms. Resch, hold on a second, Ms. Resch. Let me clarify what our issue is. So it looks to me, looking at the medical arrears, it looks like with the interest, your client's requesting $670.80 to be that portion to be reimbursed out of the $1,248. And Ms. Robinson, is your dispute? Let me make sure I understand your client's dispute. Your client's dispute is he disagrees with the Seven Hills issue, and then in addition to that, he doesn't think there should be interest. Have I got it right?
Sorry, say that one more time. You sound a little bit distant.
That's okay. I feel like I'm screaming at everybody today on the phone because to make them hear me. What I believe you're saying is your client doesn't agree with the $400 charge. Well, it's $800, but half is $400 of the Seven Hills bill. And the other issue is you're saying that your client should not be penalized with interest. Is that right?
Yes, that's what I'm saying. He wasn't notified. He wasn't, he's a joint legal custodian. He would not have consented to her going into Seven Hills. And then I know that they just said that they can provide all the emails dated back to April 1st. When she initially emailed him, he wrote her back right away saying, don't email me. I get hundreds of emails a day. I don't want these to get lost. She just continued to email him over and over. He didn't get those emails, whereas all those years before, 8 years before, they never had an issue. And since we've moved to Our Family Wizard, so thank you for that order, Your Honor, they've improved their co-parenting, firstly, dramatically. Secondly, the bills and all the money in that has not been a problem at all.
Counsel, this is what I'm going to allow you guys to do to determine. I don't know about the issue as far as the Seven Hills issue. I know she checked the child into Seven Hills without talking to Dad. That was my notes from before. But it doesn't mean that the child didn't need it. The child's ADHD diagnosis and all of that. Does Dad actually believe she doesn't need it? The minor child doesn't need it?
And he did speak to Dr. Merck as instructed, and his understanding from Dr. Merck was I did not recommend for her to be hospitalized. I recommended that she go be seen.
If they have proof of that, we haven't seen that. My understanding is his contact with Dr. Merck has consisted of 2 15-minute phone calls, and he's had no contact with the child's psychiatrist.
Okay. All right, this is my concern, counsel. Look, the issue about whether there's proof that the bills were sent or not sent, everybody says they seem to have proof. I'm going to allow it to be, because of our current circumstance, I'm going to allow you each to prepare a brief on that. I don't want to set this for, if I set it for trial, it's August or September, counsel. So my thought is, look, you guys will incur more than $624 or $670 on the top end, or $224 on the low end. That's the difference we're talking about. $224 versus $670. That's where you guys are at. In 1 hour's billable time or 2 hours billable time, that's eaten up. So my concern is, I can do a status check.
I would tell my client to meet in the middle then, because I'm going to charge.
Counsel, this is what I'm going to do. I'm going to continue that. Is there any other issues that we haven't worked out besides that issue, counsel? Ms. Resch?
Yes, Your Honor. There are a couple issues. First, my client is still requesting sole legal custody, or at least medical decision-making powers. And the court gave the father a second opportunity to become involved in the child's education and her medical providers and extracurriculars. And from my client's perspective, he has not met his burden. He's made 2 phone calls, but he hasn't met with the doctor's therapist. He hasn't attended any sessions, and furthermore, he hasn't even had any contact with the psychiatrist that the child is seeing. And he's made no appointments to meet with her teachers. He's never helped her with her homework. And he attended one of her cheer events for 10 minutes, even though my client has uploaded every single event that the child has, tumbling sessions, cheer events, and everything for him to be able to attend. And it's just very difficult for her to make decisions and move forward with care for the child when dad's not making an effort to be involved.
Okay, Ms. Robinson, what's your client's position on that?
So he has met with Dr. Merck twice. The first session was 30 minutes at least. He has not been invited by the doctor to attend any other additional sessions. When Ms. Reich stated that he has had no contact with her psychologist, that's an accurate statement. He only found out through Ms. Reich's email just yesterday afternoon that there was this other doctor even involved. So as soon as I forwarded him that message, which was immediately upon receipt, he got the email. He contacted that doctor's office immediately. Had no knowledge of him being fathered.
Your Honor, that's not true. In February, my client actually received a phone call from the child psychiatrist because dad was aware of that doctor, and they needed the custody or the divorce decree to prove that he had the ability to contact. I don't know why dad couldn't provide the decree, but they contacted mom. She provided the decree, and then dad never contacted the psychiatrist's office again.
Okay, counsel, this is what I'm going to do because of the circumstance the way it is. I'm going to continue that. Any other issues that need to be resolved besides the the medical arrears and the legal custody designation? Anything else?
It was. I have the email right here. It was February 17th. Lifebridge is where the psychiatrist that Moni sees.
Counsel, that wasn't my question. Counsel, that wasn't my question.
Sorry,
my question was, is there any other issues besides the joint legal custody issue, the medical arrears, that you've resolved the other things? Anything else that I'm missing?
The only other issue is attorney fees.
Okay.
And then, Your Honor, you already made the decision last time on the joint legal custody. And traditionally in families, we already have that one parent that is going to do all of that heavy lifting and the other parent that is going to do less. My client admittedly does less. I don't think it's appropriate, though, to strip him of joint legal custodian rights.
Counsel,
I don't recall an order being made on the legal custody issues, and I disagree. I think that if the parents share joint legal custody, then they should both make an effort to be involved in those joint legal custody decisions.
Counsel, I agree with that, except for it does always result in one parent having heavier lifting because they both don't need to call the dentist on the same day to try to schedule an appointment because it's impossible for you to do everything 100% together. It ends up having to be more of a notice versus a yeah, that's okay kind of thing. It doesn't end up having to be, because that would mean that each parent had to both call the dentist at the same time, and you and I both know that doesn't happen. Even when in an intact family, there's usually a division of labor that's different than that. So I mean, I'm not really inclined. I don't like granting sole legal custody unless there's extreme measures, and I believe that's what I said. I'm looking at my notes last time. That's what I said last time as well. My concern was that Mom took this child to Seven Hills without Dad's. That was part of our discussion last time, Counsel. I was a little concerned about that. So I am still concerned about that.
And my notes state that Dad was kind of provided this second opportunity to be involved and, get involved with the therapist, get involved with the psychiatrist, get involved with Monet's legal custody issues. Otherwise, the result would be that sole legal custody would be granted to my mom.
Counsel, this is what I'm going to do. Counsel, this is what I'm going to do. I'm going to set a status check for 2 months, especially with our current situation. See if you guys can resolve these two issues, the medical arrears and that. And at that time, if you haven't resolved it, I'll set a trial.
Okay.
Because I think Mom has met Gosh, my brain's freezing, having to yell constantly. I tell you, has met a prima facie case that there's been a change of circumstance based on the fact that Dad hadn't been involved. I don't know whose fault it is. That's the problem. So I'm going to set a 2-month status check to see where you're at on those two issues, and then I will determine from there on. We'll move forward and set a trial if I have to on legal custody. It's going to cost an awful lot for you guys to save whatever it is, $400, where you guys can't meet in the middle on that issue and on the other issues. So that's going to be my order. The return date is going to be?
May 19th at 11 o'clock.
May 19th at 11 o'clock. Counsel, I know there's both really good counsel in this case. I believe you guys can both resolve it. You guys need to talk a little more, but if not, we'll move forward and I'll set a trial at that time.
Okay. One other thing, Your Honor, before I wanted to mention, we did also reach a stipulation, I believe, that Dad has agreed to start on paying 1/2 of Monet's child care expenses.
Is that correct, Miss Robinson?
Yes.
Okay, that'll be part of the stipulation as well. Who's going to prepare the order with all the custodial timeshare changes?
I can prepare that.
Okay, that was Miss Robinson. I'm sorry, that
was Miss Resch. That's Miss Brady.
Pardon me?
It was Miss Resch.
Miss Resch. Okay, I'm sorry. It's just hard to tell who's who whenever on the phone.
I totally understand.
Okay, so Miss Resch will prepare the order from today. We'll return with, hopefully you'll resolve the other two simple items, because there's really great counsel in this case. I think you guys have a lot to you've reached agreement on the most difficult things. I think these other two should be pretty simple. So I will look forward to having a resolution on all of it. If not, I'll see you here and we'll set a trial date.
Okay.
Thank you for your appearances.
Thank you. Thank you.
Thank you.